to today's webinar, Building an IP Strategy, which is part of our series, Progressing with IP. My name is Fasiha, and I work in CIPO's Business Services branch in the Intellectual Property Awareness and Education team. Today, we're going to cover the basic concepts to understand the steps for building a successful IP strategy. Before we start, you might be wondering what CIPO does. IP rights are territorial and are managed by the IP offices of countries around the world. In Canada, it's us, the Canadian Intellectual Property Office, or CIPO, that is responsible for the administration of most Canadian IP rights. CIPO is part of the Government Department for Innovation, Science and Economic Development Canada, and we handle application guidelines, forms, and examinations used in the process to issue patents, trademarks, and industrial designs. We also work on increasing IP awareness among Canadians. So as I mentioned, we work to raise awareness for the effective use of IP by Canadians. To this end, our IP awareness and education program delivers a wide range of products and services free of charge to help Canadians better understand the importance of protecting and managing their IP assets. We are a team of content writers, presenters, and IP advisors who can assist innovators, creators, and entrepreneurs in understanding their IP before engaging in discussions with IP professionals and lawyers, where inevitably their IP will become a central point of the conversation. Therefore, we have the resources to explain what IP is, how to identify your IP, how to protect your IP, how to manage it, and most importantly, where to find help. Our tools and resources are available on our website, where we also offer fact sheets, detailed guides, online learning modules, and roadmaps explaining the steps to register for formal IP rights. We also organize seminars and webinars, and it's possible to arrange meetings with our talented IP advisors either online or in person for a more tailored discussion to your IP needs. Over the next few minutes, I'm going to be answering the following questions and explain to you what is an IP strategy and why you should consider having one, what you need to know to create an IP strategy, and how you can align your IP strategy with your business goals. We'll also look at the 6-step methodology behind the creation of an IP strategy. There's no one-size-fits-all, but it's meant to be used on a case-by-case basis and is to be adapted to your needs as a business or an entrepreneur. We'll also talk about how to manage an IP strategy effectively, and what if something changes? You'll see that it's not a linear approach, but more of a cyclical approach. So there's no endpoint to an IP strategy. It has to be reassessed and realigned with your business goals as you progress. Before we get into that, let's begin with an overview of what intellectual property actually is. IP is all around us. It's in the clothes that we wear, the coffee that we buy in the morning, the electronic devices that we use every day, and the music that we listen to on the way to work. IP comes from a creation of the mind. It's actually the form an idea takes when created that can be protected. A few examples of intellectual property include inventions, symbols, logos, pictures, designs, literary and artistic works, and many other representations. IP rights encourage innovation by giving creators the exclusive right to prevent others from stealing or appropriating their innovation. We find that most businesses have some form of IP, even when it's not formally protected. In business, IP can set one's goods or services apart from others and is referred to as property because just like real property, IP rights are acquired with ownership. Like when you own a building or a piece of land, you can sell it, lease it, or keep others from trespassing into your space. Similarly, with IP, you can sell it, license it, or exclude others from using it. And also, like real property, IP is an incredibly valuable business asset. So here on the screen you see traditional types of IP and the registered rights that are associated with them. Let's take a deeper look at each of them. Starting with trademarks. Trademarks are signs that distinguish one's products and services from those of others in the marketplace. A trademark can be a word, symbol, a design, or even a taste, sound, scent, texture, or more. It's what consumers often first see and how they navigate in the marketplace. It's really about being distinctive so that they can easily identify a trademark with the associated product or service. It's also important to note that trademarks can also include geographical indications and certification marks. Now, patents are all about functionality. They're about providing technical solutions to a given problem. It's the way you can protect new or improved products, machines, processes, and compositions. The invention to be protected has to be new to the world, useful, meaning that it must work, and inventive in order to be eligible for a patent. Then we also have copyright, which typically protects music and artistic creations. Copyright is all about original expression and creations that use some level of judgment and skill and are not just a mere copy of another work. And then we have industrial design, which concerns the appearance of an object. It serves to protect the unique appearance and aesthetic of a product. It's about what appeals to the eye, so this could be unique shapes, patterns on clothing, fashion accessories, technological devices, etc. And lastly, we have plant breeders' rights, which protect the varieties and denominations of new plants. However, CIPO actually doesn't manage the application process for this. Instead, it's the Canadian Food Inspection Agency that takes care of those. So while IP includes valuable information, it's important to note that there exist other types of IP which also hold valuable information but cannot be formally protected. A good example of this is a trade secret. It can be any business information that derives its value from its secrecy. It can be a method, a technique, any know-how, research, analysis, data, a customer list, a formula, a recipe, etc. It just has to have some sort of competitive edge, but one that cannot be formally protected. Trade secrets are incredibly valuable. However, they may not be the best choice of intellectual property protection if your competitors can easily reconstruct or reverse engineer your creation. And remember, reverse engineering is when you can recreate a product just by looking at it or seeing how it functions. There are other examples of non-traditional IP as well, like domain names and websites, which, despite common belief, are not the same as trademarks. And then there's also social media accounts, which can contain a lot of IP, such as trademarks, copyrights, and more. So you're surely wondering at this point, why should I have an IP strategy? What are the benefits associated with it? Well, an IP strategy is essential to impress potential investors. It shows them that you have considered the risks and opportunities associated with intellectual property, and by protecting your ideas through patents, trademarks, and other IP rights, you demonstrate your commitment to gaining and sustaining a competitive advantage. So, first of all, your IP strategy provides tangible evidence that there is indeed a market for your product or service. By safeguarding your IP, you show that your creations have value and are in demand. Second of all, your business strategy is also supported by your IP strategy. It explains how you will go about researching your target market and reaching it, and includes essential elements such as market research and product differentiation to establish the foundations of your success. An important element your IP strategy allows you to build and accomplish is turning your ideas into valuable assets. With your exclusive rights, you can create value that attracts investors and potential partners. You have complete control over your creations and can totally capitalize on them. As well, monitoring your IP footprint is another key advantage of your strategy. It enables you to stay vigilant against potential infringements of your rights and allows you to take swift action to protect your assets when needed. And finally, your IP strategy provides a powerful means to fend off competitors in your space. With a strong IP portfolio, you deter others from copying or imitating your products or services. All in all, this ensures that you remain a leader in your industry. So when investors show interest in your company, it's natural that they may ask some important questions about your IP. For example, they may ask, have you considered IP? And to this, you could respond that you have been proactive in protecting your ideas and creations, and mention perhaps that you have filed patents for key innovations or any other respective IP right that relates to your innovation. They might also ask, does your IP protect your unique offering, and where does it do that, and for how long? And for this, you could explain that your IP secures what makes you unique in the market. For example, a patent protects our cutting-edge technology, you could say, by giving you an advantage for 20 years. And now they might ask, who pays versus who owns IP? And when employees come up with new ideas, who becomes the owner? A possible response could could be that everything is clear in your employment contracts, and that's where you hash out these finer details. You might also find that they ask, is your IP in a crowded space? And to this, you want to be clear that you've conducted your thorough research to avoid overlap with other companies. For instance, you could mention market studies that have ensured that you have confirmation that your concept is unique. You could also be asked about who else knows your secrets. And for this, you should prioritize confidentiality in your responses and stress that only specific members of your development team have access to ongoing projects, and that you try to keep things on an absolute need-to-know basis. And lastly, you might find that they would ask, is IP ownership specified in your contracts? And to this, you might respond, yes, we have clear agreements on intellectual property, and that our contracts explicitly state that any IP developed within the scope of your business belongs to you. And so by addressing these questions, you demonstrate to investors that you have a solid strategy for managing and protecting your IP, and overall, this just allows you to enhance the value of your company in the market. And when it comes to IP, there are, of course, many common mistakes that come up. So let's talk about a few of them that you should try and avoid if possible. And taking care of your IP and understanding it well can certainly help in that process. For example, first of all, waiting too long to start protecting your IP. Understanding the importance, or perhaps underestimating the importance of safeguarding your innovations as early as possible, is detrimental. This waiting could lead to the loss of valuable IP rights for you. So imagine it this way. Imagine developing a groundbreaking new technology. By promptly protecting it with a patent, you automatically prevent others from copying it while you wait. Second, losing your IP just because you don't realize you have it. So ensure a clear understanding of which aspects of your business are protected by IP and defend them against infringement. A third mistake to consider, infringing on someone else's IP unknowingly. So for this, it's really all about being vigilant about others' intellectual property rights and avoiding unintentional violations. So imagine developing a new product and launching it overseas, only later on to discover that it infringes on an existing local patent. This mistake could easily be avoided with proper prior research, so really emphasize that during your development process. You might also find that you don't know nearly enough about your competitors. And for this, it's really important to investigate your competitors' patents, trademarks, and copyrights to avoid future disputes. Avoid investing time in creating a unique trademark for your new products if it closely resembles a competitor's. You risk having your trademark registration denied because it's confusingly similar to the other. And lastly, you may face ownership issues with IP due to a lack of appropriate agreements and contracts in place. So for this, again, it comes down to ensuring clear and appropriate agreements regarding IP ownership with your employees, co-founders, and partners, and whoever else may be involved. So imagine creating a revolutionary software with a partner, and without a clear IP agreement, you could really find yourself in a disagreement about who owns the rights. So being well-informed and conducting thorough research can help you avoid all of these types of mistakes and overall just better manage your IP. So now I will play a video to illustrate several points that will be discussed throughout the course of this presentation today. This is called Bianca's Boots, and it's actually taken from our YouTube channel. So I'll let you watch it, and then I will ask you some questions related to it throughout the course of this presentation. And just as a setup, it is a fictional scenario with someone who innovated and encountered certain obstacles along the way. So we'll use this as a starting point to discuss the various aspects related to the IP strategy. So now you'll see on screen the methodology that I...
Meet Bianca, our fictitious inventor and designer. Aww. Bianca has designed a sturdy boot built to last through Canadian cold winters. It has special soles to prevent slipping, a high-quality lining for warmth, and a few design details so that consumers can quickly identify Bianca's boots in the store. When Bianca created these boots, she was convinced they'd have potential in the Canadian market. She submitted and obtained industrial design registrations for the various aspects of the boot's unique visual appearance and registered a trademark for the brand. Once the boots were available in the store, the success was almost instant, and Bianca was very happy. Quite soon, some of the competing brands started to produce sturdy winter boots, but at a lower price. To stay competitive, Bianca decided to investigate if she could source some of the materials from the boots from elsewhere. Wearing her boots, she traveled to a range of countries to talk to material suppliers and manufacturers and found a few businesses willing to help. Once again, Bianca was successful. She found suppliers abroad to help her reduce the price of the boots so that she could keep and even grow her market share. Things are going well. Soon, Bianca will celebrate the first shipment to the United States. This is a big step into a much bigger market. As the winter is coming to an end, Bianca is investigating if she could expand into Europe, where sturdy boots are also popular. But as she looks online for boots in Europe, she discovers that several stores in Europe are selling very similar boots. They look like her boots. She reaches for the phone to call the stores in Europe, but before she can dial the number, someone from the US calls to notify her that the shipment to the US has been detained by US Customs and that it's infringing on someone else's IP rights in the US. How is all this possible?
So now you'll see on screen the methodology that I was referring to earlier, which is the 6-step IP strategy. And I'll talk about each one in more detail today. But in essence, an IP strategy is a plan that explains how you will use your IP to achieve business objectives. Generally, when starting a business, there are commercial objectives and a business plan is created. So that might include short-term, medium-term, and possibly long-term goals being set. And the goal is to add the IP strategy to this creation process and aiming to align all of it together because really it can all complement each other and optimize the achievement of your business objectives at the end of the day. For example, if one of your business objectives is to export to a new market in another country, you manufacture products in Quebec, Canada, and you are ready to export your brand to a different country. It could be opening a store or placing your products on shelves. This whole process is where IP can come into play. In Canada, do you have a protected trademark for your products or services? Do you have a patent supporting the technical aspects behind your innovation? If you are entering a foreign market, you need to ensure that you can export without infringing on the IP rights of your future competitors. So is the trademark, for example, available in the country that you are interested in? Does that patent already exist? These are all the kinds of questions that you will want to ask yourself and you will want to know the answer to. And the IP strategy will help you gain some further clarity on this. So with these 6 steps, you will need to perform first an internal audit and then an external audit of the IP. Then you'll need to perform an analysis of your findings and then the creation of a plan, which then leads to the implementation of the strategy and finally the reassessment and reorientation of the strategy. So it is a cyclical analysis. And after step 6, we go back to the first step and restart the exercise with the aim of adapting to changes in the market and facing whatever competition may be in the way. Now, what do you need to know in order to actually create an IP strategy? The first step is to determine the value drivers of your business and how you can protect them. So identify the key elements or aspects of your business that contribute the most to creating value, whether it's financially, strategically, or in the market. When defining your business objectives for the next 2 to 5 years, try to consider the following. What products, features, or services will you sell? What makes your company competitive? What other technologies, brands, or confidential information does the company use? Consider the location. In which markets do you want to produce, sell, establish, or expand? And regarding financing and partnerships, what sources do you have or need to access to achieve your goals? So starting with this exercise should give you a better overview to formulate your strategy and certainly start thinking about those steps in a bit more of a practical sense. And further, for your help, we have our IP strategy self-assessment tool. This is a way for companies to extract the most relevant sections of our IP strategy guide overall. So the user answers a handful of questions, which are of course non-confidential, and can then download their custom guide over the relevant considerations in an IP strategy for their business or startup or whatever endeavor it may be. So this is one of the most comprehensive guides that we offer to SMEs. And at the end of this presentation, I'll provide some more information on how you can access it because it really is quite a valuable tool. So now taking a deeper look into the first official step of an IP strategy, which is the internal IP audit. With this, you need to identify what you already have within your company. So if you're a sole entrepreneur, you'll have to determine what you possess in terms of official and unofficial IP assets, possibly trade secrets or other confidential data, whether it's technical data, unique know-how, customer lists, any type of inventory like that. So really take inventory. It's crucial to do so. And in a moment, I'll show you another one of our resources that can actually help you with your internal IP audit. It's the same principle as if you were moving to another country and had a limited number of things that you could bring with you for the move. So you would take inventory of what you have in your house and make strategic choices. This comes with us, this doesn't. And so it's the exact same mental process for IP. You'll make a list of everything you have in your business in terms of IP and then make strategic decisions on what needs to be amplified, what needs to be shelved, etc. So now let's backpedal a little to the video that we watched called Bianca's Boots. And I have a question for you. What types of IP do you think Bianca had in the video? So hopefully you've ruminated a little bit about possible answers, but let's just get right into it. Bianca developed boots with particular features to withstand harsh Canadian winters, as we all know them here. And the first thing that we can think about is the boot's visual aspect. So when we look at Bianca's boots, the eye is immediately drawn to the shape, the look, the colors, the innovative kind of visual aspect of them. So here, what we are talking about is industrial design. And in the video, it's mentioned that Bianca obtained industrial design registrations for various aspects of the visual appearance of her boots. So when you have a registration for industrial design, it means that the boot has a unique shape or visual aspect, something that we'd never seen before. So this type of IP protection can be granted. And again, there's an emphasis on the concept of industrial design because when examining an application for industrial design registration, in the sense of the law, CIPO is not at all interested in the aesthetic side of the article. So just because an object is beautiful doesn't increase the chances of obtaining registration for it. It's really the innovative aspect that is truly considered. So this article must be original, must be something that we've never seen before, and so even if the boots in question are not to the subjective taste of the examiner, that has nothing to do with whether or not the registration for the industrial design under review is granted or not. In the video, we also talked about a trademark. So she obtained a trademark registration for the brand of her boots, and the video actually does not specify what a trademark is, but that there is a registration for a trademark. So she has two different types of IP then, industrial design and trademark. In the past, other responses have included that Bianca had a patent for the insulating material used to insulate the boots. In the video, Bianca does not allude to a patent, but it very well could have been possible, because when we talk about patents, we are completely interested in the functionality, the technical solutions, and more importantly, the solution provided to a problem through that invention. So yes, it could have been a matter of a patent if the insulating material had met the patentability criteria during the examination, but this is not the case for Bianca's boots. So for the same finished product, it is possible to have more than one type of IP, a trademark, an industrial design, and potentially a patent. But here, Bianca kind of made a little mistake in that process, and we'll come back to that in a little bit. So back to the resource that I was mentioning earlier, the IP inventory checklist, which can be downloaded or printed, whatever you prefer. It's very simple to use. You just need to go through the document and check whether you possess the various types of assets listed. And this can give you a direction on what types of IP you should consider official or not. For example, for a slogan, the relevant IP to consider is a trademark, and the action to take is to apply for trademark registration. So this checklist will help you identify your assets, the type of IP to consider, and the steps to take when conducting your inventory. So knowledge and compliance with IP rights are commonly discussed topics with our IP advisors and also with the information officers at our customer service center. And at the end of this webinar, I'll provide you with the relevant contact information to get in touch with both of those service providers. So back to dissecting the different steps of an IP strategy, the second step is to conduct an external IP audit. This is a crucial step that requires a lot of attention because it provides an overview of what your competitors are doing. So an external IP audit involves taking the conclusions from the internal IP audit and examining them within the IP landscape. So how might this affect your business goals? You will use different databases to find this type of information, and in a little bit I'll revisit the database topic again. But during the external IP audit, you need to look for traditional forms of IP that could prevent you from doing business in your target markets. So for instance, if you plan to expand into the American market, really consider and research if you can register your trademark there. You need to ensure that the IP right that you are interested is not already owned by someone else in a different location. Another kind of aspect to verify is, can you identify other intellectual properties that could make achieving your business goals a bit more challenging? So, for example, are there other companies in your target market that own trade names or domain names that could be confused with your own trademark? And another company with a similar name or a closely related domain name to your trademark could ultimately cause confusion within the market, and customers might mistake your business for another, and ultimately that has the potential to harming your reputation and your sales. And additionally, you might face legal disputes for intellectual property rights infringement, which of course, as we know, can be incredibly costly, not only in terms of finances and resources, but also time. So when it comes to the external IP audit, why should you do it? What are the main motivations that you should consider in making that happen as part of your IP strategy? There are at least 4 good reasons to learn about others' IP and really give the dedication to the external IP audit that it deserves. First of all, it's important to minimize the risk of infringing on others' IP. IP rights are legal rights, and certain international trade agreements have strengthened the legal framework surrounding IP, so infringements can be quite severe. Unauthorized use of someone else's IP rights can result in fines and even imprisonment. So at a minimum, a business should ensure that its commercial activities do not infringe on the rights of others, and a huge part of that is doing the research and that relevant due diligence. Second of all, it's important to do an external IP audit because it allows you to avoid wasting time and money developing a creation only to realize that it can't actually be protected. So knowledge of IP related to a creation or innovation can help a business avoid investing precious time, resources, money in something that something that someone else has already protected or invented. You also need to determine the IP and collaborators for licensing. Only a fraction of existing IP is commercialized, so even if the IP already exists, it's not always an insurmountable obstacle. It may sometimes be possible to obtain it through licensing. For example, with universities, governments, and private organizations, they collaborate to offer their IP assets as licenses for this very reason. And finally, gather information about competition regarding new trademarks, inventions, and designs. Understanding all of these elements and the IP landscape in a broader kind of sense is an extremely valuable exercise for your business. Surprisingly, much can be learned and deduced from publicly available data, so definitely don't overlook this kind of last benefit of performing what might seem copious, an external IP audit, but it is ultimately incredibly rewarding for you as a business. Now, what data specifically should be searched for, or what should you look for? You could start by researching or searching for IP in all territories that you intend to conduct business. So take note of places where your competitors have protected their IP already. Look into territories where you suspect someone might want to produce, sell, or traffic illegal copies of your work. And at this stage, you need to continue gathering information on other companies and your competitors. So identify the IP rights and the position of your suppliers, distributors, and customers. All of this can impact your business. For example, check the trademarks registered by your manufacturer. Make sure that they're not too similar to your trademarks to avoid unnecessary confusion. It's also important to gather information on inventors and creators. See if you can identify key inventors, creators, designers, who they collaborate with, etc. All of this can be considered an indicator of the strength of innovative capacity within a company. And some companies rely less on their own research and acquire, through licensing, the IP of others to kind of further develop their process. It's also important to gather information on all relevant innovations within your field. So identify the latest innovations, look at IP rights databases as they allow you to become aware of current innovations long before they actually are publicized or reach the market. For instance, most patent applications become accessible to the public for the first time when the subject of the application is published. So in the case of a patent, this usually happens 18 months after filing. You might find patents or industrial designs similar to yours, but none are on the market. So this could be a sign that the innovation may not have sufficient commercial potential, and that the holders of these earlier patents may have decided that it wasn't profitable to pursue, which is something that it saves you a lot of time and resources if you just do that research. And lastly, the existing IP rights of others in relation to your business activities should be considered. Ensure that your planned or existing business activities do not infringe on others' IP rights. This reduces the risk of future problems, including wasting time and money to protect your creation only to find out that it actually cannot be protected, from facing legal action if you violate the IP rights of others, having to acquire IP rights from others to begin with, and having to change the brand or presentation for your new product if the trademark name or logo is already used by someone else or cannot be protected. Information about IP rights is public. The agreement with the government is that in exchange for the full disclosure of your innovation, if it meets the criteria assessed during the examination to become a patented invention or registered trademark, in exchange for that, the information becomes public and you are granted an exclusive right. You might also be asking yourself, why is it public? That's because that promotes the dissemination of knowledge and innovation, and others can become aware of existing innovations and be inspired to develop new ideas, improvements, etc. And it just all stimulates the technological progress for that relevant group. So now that we've spoken and discussed at length about why external IP audits and information is so important, where exactly can you find most of that information? To gather external information on intellectual property or IP, you can look at IP databases, which are available for free, but some of them do require expertise because it's not always easy to find the information that you're looking for. It's highly relevant to seek assistance from an IP professional for this. You can also look at scientific literature. You'll find reviews, inventors and creators, as well as trends and kind of unmet needs that might be relevant. You can also look at company websites to explore products and their features. These are good keywords to search for. Some companies list their patents or new versions of their products, so you may sometimes find those readily available as well. And you may also find customer reviews, usually quite objective, satisfied or not, and notifications for why they're not satisfied, and some sites may even mention the possibility of licensing agreements. So company websites can be quite insightful for this external information. And then lastly, try to look at online shopping sites to find company names and kind of track manufacturers and distributors, and reviews to indicate consumers' preferences or preferred features and areas for improvement. All of this is available. You just have to put in the work and get into doing this research in a comprehensive manner. It's not always easy, but it is, as we've discussed, incredibly rewarding. And for some of them, it's just much more beneficial to work with an expert to ensure that your research is reliable and totally comprehensive of everything that it needs to be. So here is a concrete example of an external IP audit that you can observe. The data presented here is from 2017, but the information is still relevant. It involves conducting research using the product and service classes used for trademarks, and by doing this, you can discover for which types of products and services people are registering their trademarks. So in the United States and Western Europe, the main classes that received trademark application requests were related to research and technology, as well as business services. On the other hand, in China in 2017, trademark applications were primarily related to business services and clothing. So if your business falls into any of these sectors during this or whatever relevant IP audit you might find for 2023 or whatever year, this information informs you that numerous trademark applications have been made in these types of products and services. And if you are also operating in these sectors, you will need to exercise extra caution as the competition is likely to be fierce. And so this kind of exercise can be extremely enlightening, and it allows you to kind of understand the highlighted points in the industry and the potential risks of operating in such a competitive market. Obviously, there are significant limitations to also be aware of. You may never be able to find everything on your own. Even with the help of an expert, sometimes there are, of course, certain limitations. So for patents, you will be confined to publicly accessible data. So due to its nature, a patent application becomes public 18 months after the filing date, and afterward, information about the patent will become available in databases on various websites. So it's important to access information that is secret and kept confidential. That is, in fact, the purpose of all of this. And due to the complexity of claims and languages, it's practically impossible to find every piece of relevant patent publication. Now, when it comes to trademarks, note that common law trademarks are not listed with registered databases, so you're limited to registered trademarks and trademarks for which an application is currently under examination. As for legal business names, you must ensure that the business name that you are considering does not already exist. So searching for existing business names could help you avoid having a trademark that could cause confusion. And searching for trademarks is complex. It requires good knowledge to identify potentially confusing trademarks using similar sounding words with similar meaning, etc. So for this, you again want to be incredibly vigilant. And for industrial designs, you will not find designs in all countries. In some countries, the data is not available or no IP rights are actually granted for designs. So you might have to do a bit of extra research when it comes to industrial designs and whatever relevant foreign market that you were looking to expand in. And lastly, with copyright, it's automatically established when a work is created and fixed in a given form. Most countries have a system in place to allow for the formal registration of copyrights, but it's usually only searchable by title. So for example, if I compose a song and you go to CIPO's database, you can only search for the song title. If you only remember the lyrics and try to put those in, you won't be able to find the work. And the same applies if you're in the visual arts or creating original works like a play or photography, or even in the software development process, and you seek copyright protection for either of those. It's not easy to find what you're looking for. So being really specific and doing your research, once again, is key. So now that you've completed the internal and external IP verification exercises, it's time to determine and analyze these conclusions, which is the third step in the IP strategy process. So you may have identified opportunities, or conversely, you may have identified gaps in the protection of your IP. So your overall IP strategy, it must align with your business plan. And for this, you can ask yourself the following questions. Are your IP rights where your business operates? So make sure to analyze the IP rights, yours and others, in the geographic markets where you plan to develop and sustain your business. You might also ask yourself, when will you need a specific type of IP? So for this, ensure that you protect the elements that differentiate you, and don't forget processes that may be trade secrets. You want all of this information to remain confidential. You need to put the measures in place to keep it that way, and again, that just comes with being highly vigilant and specific and getting to things in a timely manner. You might also find yourself asking, what are the common industry rules? So products and services are often subject to various regulations and standards to ensure their safety and the ability to measure, compare, integrate, etc. So don't forget to, again, thoroughly research industry rules and standards. CIPO collaborates with the Canadian Standards Council to develop information sheets and webinars on IP and standards. And on the CIPO website, we have an information sheet on this topic specifically, and it's really quite insightful. So if you want some more information on standardization within different industries, be sure to check that information sheet out. And then also, overall, it's just important to consider the temporal aspect when managing IP. So for example, imagine someone wants to present a prototype during a presentation. Since prototypes are often improved, it may not be the right time to file for IP rights at that stage. So an analysis would identify which parts of the invention could eventually be protected by IP rights. And in this case, there is a short-term gap in IP protection since the inventor wants to present the invention. With that stage, the inventor should first minimize disclosure, otherwise it might not be possible to patent the invention later on. And with formal IP rights, filing might be appropriate in the medium term. So for example, if a company needs to hire someone to develop new IP to operate the technology, in this case, before creating new IP, it would be important to ensure that the employee contracts include provisions regarding IP created during the collaboration with the company and specifically what all of it means. Before starting to work together, it's advisable to identify existing IP in order to differentiate it from what IP will eventually be created during the course of the collaboration. And now think about the long term. Consider the value over time of IP rights relative to the product's life cycle. Some industries have product life cycles that are as short as 1 to 2 years. Compare this to the time that it takes to file and process a patent application, which is usually several years. In the long term, it might be worthwhile to voluntarily review the IP portfolio by abandoning IP rights or granting licenses. And as the company evolves, it may be worth exploring access to others' IP through licenses to create an even stronger portfolio. So in summary, the analysis of IP verification should be done considering what IP the company owns and needs to achieve its goals, and when, where, and how IP should be acquired and protected. So overall, this step is critical to move on to the next step, which is creating the plan. So now let's backpedal a little bit to the Bianca's Boots video again. In your opinion, what were some of the shortcomings in her IP journey before expanding internationally? Eventually, Bianca received a call from the United States informing her that her and her boots had been seized by U.S. Customs. Her boots were infringing on someone else's IP rights in the United States, but she did not encounter this issue in Canada, although it's not mentioned in the video. Therefore, a shortcoming that we can easily identify was that she either did not conduct thorough enough research or that her research was not extensive enough to know that someone else had already held those IP rights abroad that were similar to hers. So she made the mistake of not anticipating protection abroad for industrial designs and trademarks. What Bianca should have done is that she should have filed registration applications abroad for her boots, or at the very least ensured that she was not encroaching on someone else's IP rights. So she should have considered, is the trademark still available in the United States? Has the design already been registered? These are all important considerations to keep in mind here. Now, the fourth step to develop an IP strategy is to define the actions that will bridge the gaps that you've defined or some of the shortcomings that you've identified. So this is when tactics in the IP plan become important. This isn't a one-size-fits-all approach to intellectual property portfolio management. Your tactics will be based on a range of factors that include your current IP assets. So are they aligned with the business and revenue goals for their respective products and services? Consider any potential gaps resulting from the differences between the IP versus a product's life cycles, and also make sure that you have properly identified your IP assets in step 1 and that you're taking the steps to protect them and register them formally. You also should consider your field of operation. So for example, software companies are going to have different considerations than companies with retail consumer products, and those will be different than the strategies for service providers. And sometimes, upon careful consideration, a company may decide that its products are not protectable through patents or that there is no advantage to patenting. And in other cases, using trade secret law to protect innovation is actually a better approach than filing patents. And then you also want to consider quality versus quantity. So understand the quality of IP for a business. And that exercise is a subjective matter and is therefore a product of the IP culture that's often directly fostered by corporate policies. So for example, a business that focuses policy on high volume patent generation and at a low cost may encourage employees to forego patent quality in an effort to maintain that filing pace. However, a business that focuses policy on advancing business-relevant IP assets or critical know-how through IP processes for approval may be better able to create a supporting culture that understands how IP quality is defined and rewarded. Then you also want to consider your timing. You could face time-sensitive considerations or issues for the registration of IP rights. So, for example, trademarks offer more time in contrast to patents, the 12-month grace period for patents, the different examination service standards, etc. Those are all important to keep in mind when making these filing decisions. And then, of course, your future plans. Take a look at your business goals and the gaps that you've identified. What are short-term gaps and how can those be filled? What are the medium-term and the long-term ones and how can you work towards addressing those? For example, if a startup company is based on IP rights it has licensed from other IP rights holders, will these arrangements be sufficient to attract future investors as you scale up the business? Is there a sufficient operating budget to retain and secure new IP rights? Can you weigh the pros and cons for possible scenarios if the budget changes? Companies, both big and small, take a variety of approaches when it comes to protecting IP. Some companies focus on product development and marketing with little focus on protecting intellectual assets, while others narrowly protect their own products or planned products. So when developing a comprehensive IP strategy, a company should consider the reasons for protecting IP in the first place, including the need to protect income streams and recover investment in product development, the desire to obtain a competitive advantage, the benefits of fencing in competitors' positions, and the need to enhance equity value and impress or attract investors and sustain that. So there are different types of strategies that can be adopted by a business. Here on the screen, you just see a few examples, and it can also actually be a mix of several types of different strategies. So I'll start with the defensive strategy. This strategy involves establishing a stable IP position to protect against external threats and avoid legal actions. So a concrete example of this is a pharmaceutical company that has a robust portfolio of patents to protect its innovative drugs, and it also uses trade secrets to keep certain information confidential and prevent competitors from copying its product. So that, in its essence, is really quite defensive. An offensive strategy aims to create an IP position to block competitors' growth and increase the company's valuation. So an example of this is a tech company that wants to attract investors and enhance its value. In order to do that, it files blocking patents to protect its unique innovations, which of course deters competitors and strengthens its marketing position overall. And then, of course, we have the licensing strategy, which involves acquiring IP assets with the goal of generating income through licensing. And a concrete example of this is a software company that owns highly sought-after patented technology, and it actually starts granting licenses to other companies to use this technology in exchange for royalties, which allows it to generate additional revenue. Then we also have the financing strategy, which involves acquiring IP assets to increase the company's valuation and facilitate significant financial transactions such as investments, mergers and acquisitions, or even setting up for an initial public offering or an IPO. And a concrete example of that would be, again, a technology startup that aims to raise funds from its investors. So it acquires patents and trademarks to strengthen its intellectual property and enhance the perceived value of the company to potential investors. Of course, these are just a few examples. In reality, this can all be a combination. It's a bit like giving personality to your strategy to make it representative of what you want to achieve within your own company. So as you continue developing your IP plan and strategy, it's essential to consider several other important elements, such as your budget. So carefully analyze the financial considerations related to IP and do not hesitate to seek the assistance of experts if necessary, as these costs can build quite quickly. Define a realistic budget for expenses related to patent filings, trademark registrations, the different maintenance fees that are associated. It all adds up really fast. So make sure you keep tabs on how those finances are growing and that they're within your set budget. Of course, you also want to consider the scope. So take into account the entirety of IP rights over time. Ensure that you have a thorough understanding of the scope of your IP rights for each innovation or brand, and thoroughly examine how these rights may evolve over time and what that might mean for you as a business. And then, of course, it's important to consider standards as well. So keep in mind common industry rules and standards, or perform comprehensive research in order to get familiar with those rules and standards, as they could severely impact your intellectual property. Some products or services are subject to very specific regulations, and it's really important to comply with them in order to protect your IP rights, but also to ensure that you can actually sell your goods or services. And then, of course, it's important to consider the filing systems. So explore the different filing options for international IP applications. If you plan to market your products or services internationally, you may need to file IP protection applications in several different countries. And you can watch some of our other webinars for more information on those international systems and how they apply to different IP rights. And then lastly, you really want to keep at the top of your list of considerations your business operations, including manufacturing, marketing, and your sales strategy. So ensure that your IP rights align with your business activities and that you have the necessary protections to prevent any infringement of your rights. Overall, by taking these factors into account, be better prepared to develop a strong IP plan tailored to your business goals. And then, of course, if I can stress one thing, it's that, don't forget to consult IP experts to help navigate these various aspects and make the best decisions to protect your innovations and brands. They're there to help you. They're experts at what they do, and their insight is quite valuable. So once again, CIPO is a great example of that niche kind of expertise that you can access by looking through our resources. We have a ton of them to assist you with strategic IP planning. So among them are the roadmaps that are available on our website, and these explain the various steps that you need to take in order to obtain a trademark registration, for example, or a patent filing, etc. From filing the application to registration to renewal of the trademark and everything that can happen between all of these different stages, you'll find all of that comprehensive information on our roadmaps. We also have guides for different countries. So if you're considering protecting your trademark abroad, good summaries to get an idea of how things work in certain countries. It's a good idea to take a look at these different international or IP abroad guides as we have them on our website. Some of the countries that we have include Germany, Australia, China, the United States, and some others as well. Now let's talk about how you can communicate and actually implement the IP strategy within your company, which is step 5 of this IP strategy process. So while certain parts of the strategy remain confidential, and they should remain confidential, from an operational or an implementation standpoint, an IP strategy should not be a standalone plan to execute. It should not be managed solely by the legal team or the research and development team. Your IP strategy should be an essential component, and it should be integrated into your overall business strategy. So some parts of the strategy should be shared with your staff and top management during the execution, which is true, but it should also be understood by your advisors, executives, and board members, if applicable, so that you can better assess the risk profile and the risk management required for all employees. So your employees need to be aware of their responsibility in protecting the company's or the firm's intellectual property. In any case, the organizational structure, corporate policies, and cultural environment of your company should both support and be supported by your IP strategy. And of course, a huge part of this is engaging and educating people about IP. So don't forget to monitor the market and defend your IP rights, detect infringements, and work with IP experts to resolve them. There's no police force to protect your IP. Once your IP rights are protected, it does become, automatically it becomes your responsibility to monitor and police the market and defend your rights if necessary. Now we're talking about a culture of IP. So how do you manage your IP strategy? How do you sustain it? IP culture refers to how a company views and manages IP issues in all aspects of its operations. So some important points to consider in the IP culture include, first, the default ownership position for IP. So it's essential to establish a clear default position regarding the ownership of intellectual property created within the company. For example, some employment contracts may specify that any IP developed by employees in the course of their duties automatically belongs to the company. Second, you want to consider different modalities of IP in your contracts. So when entering into contracts with partners, suppliers, or subcontractors, it's important to specify the IP rights associated with the provided products, technologies, or services. For instance, a software license agreement should clearly define the user's rights and the IP ownership granted. And then, of course, we have the internal and external disclosure processes for IP. So an IP culture encourages awareness of the need to protect sensitive information. Internal disclosure protocols should be established to ensure that confidential information is shared only with authorized individuals. And additionally, during external disclosure, such as when seeking partnerships or marketing products, it's important to protect key information with legal confidentiality agreements. And then lastly, we have IP research and monitoring. So IP culture involves conducting regular research to identify existing IP rights that could impact your business activities. This includes monitoring trademarks, patents, and other IP rights within your industry. So for example, when developing a new product, it's crucial to check for existing patents that might prevent you from marketing it. In summary, an IP culture relies on a proactive approach to IP management within the company, emphasizing ownership, contracts, disclosure, and IP monitoring. By adopting such a culture, companies can better protect their innovations and their IP assets, and overall, they just strengthen their competitive advantage in the market. So the integration of IP policies and default positions within corporate policies is essential to ensure consistent and effective IP management. This encompasses several key areas of the business, including human resources management. So it's crucial to clearly define who owns the IP within the company. Additionally, measures should be established to ensure that both new and existing staff members protect confidential information and trade secrets, and contracts and confidentiality clauses are essential tools to address these issues. Second, we have sales and manufacturing. So here it's of course necessary to determine which IP-related information should be disclosed to external stakeholders. And furthermore, it's important to specify which IP-related information can be allowed to be shared with other parties while avoiding premature disclosures that could actually compromise IP protection. And then lastly, we have the R&D partnerships. So the management of jointly created IP must be carefully planned. Partnership agreements should define the rights and obligations of each party regarding, resulting intellectual property from those partnerships. And the IP development strategy should align with the overall business strategy, whether it involves offense, defense, licensing, or finance. Overall, this also applies to the open innovation policy compared to closed innovation. Some corporate cultures favor openness to innovation, allowing their employees and partners to share and use internal and external ideas. This can enhance the market value of products or services, but of course, one must be aware of the risks associated with excessive disclosure. And of course, other companies prefer closed innovation and are focused on internally developing IP. The partnership policy must also be well defined, covering access to technology, markets, and relevant information. And partnership agreements should align with the company's IP strategy and clearly define the rights and limits of each party. And finally, it's crucial to establish mechanisms to protect IP, including non-disclosure agreements or NDAs, and procedures for protecting trade secrets. Integrating these elements into corporate policies helps create an extremely strong IP culture and ensures the protection of intellectual property assets in a constantly evolving environment. And just for you as an entrepreneur or as a business leader, provides you with some peace of mind. Now, I'd also like to get a bit more into detail about something that we've heard come up throughout the course of this hour quite extensively, which is contracts. So both internally and externally, contracts are an extremely important mechanism to protecting IP. An assignment agreement is a contract that transfers the rights to the IP from the creator to another entity, such as a company. It's a good idea for companies to have in place agreements to make sure that IP created by employees or contractors is assigned to the company. Non-disclosure agreements, or NDAs, also sometimes known as confidentiality agreements, are used in almost all aspects of business transactions, but particularly they're important when dealing with intellectual property, especially if it isn't formally protected yet. It's an extremely important step in safeguarding that really precious information. So while you are still improving your innovation, it's often impractical to acquire formal IP protection. So confidentiality agreements are definitely the only effective way to protect IP at that stage. And then remember that NDAs must be signed before disclosing confidential information, but any disclosure almost always increases the risk. But if you do follow some concrete steps to ensure that it all stays within the circle of trust, or it's on a need-to-know basis, or it's protected, then you should be okay. So if we revisit Bianca's boots story, who do you think Bianca should have discussed IP with, and how could she have done it? Well, she should have discussed it with an IP expert, a trademark or a patent agent, and presenting her product and outlining her short, medium, and long-term goals, she could have engaged with them in a meaningful discussion. So clearly there was a gap here. Bianca made the mistake of not checking whether similar boots to hers were protected abroad in the targeted regions, and then of course we saw the results of that. And now let's talk about the IP strategy's sixth and final step, which is to reassess and realign the strategy. So a good way to look at it is as if the IP strategy is a living plan, and it should reflect how a business will use IP to reach its business goals throughout the different stages of its progression. So therefore, it's necessary to regularly review and reorganize your intellectual property assets. The frequency of review varies for different businesses and their IP portfolio sizes. Use the IP inventory where IP is aligned with the products and services. So business objectives or revenue models may evolve over time. You might find new competitors may enter the market and disrupt the current market dynamics completely. So maybe what seemed to be sufficient protection in the past is no longer sufficient in these new markets. So what can you do about it? Stakeholders may change, for example, strategic partnerships with researchers, distributors, manufacturers. These are all key considerations. And then, of course, assets can become expensive to maintain. So the cost of securing IP assets through registration and prosecution should be weighed against the business value. And make sure to follow up that pending applications are progressing the way that you intended. For example, do the patent claims still cover the essential parts that you want to protect? And similarly, the cost of maintaining IP assets should be weighed against the business value. You might also find yourself with the following questions. If a business suddenly offers its products online, is the trademark protected the same way? If a company sources products from a new brand, is the brand protected, or can other manufacturers copy the brand without infringing? So any company can be affected by unforeseen factors, which could be reasons that an IP strategy needs to change or evolve or adapt. Some of these factors to keep in mind could be external, so different regulations, economic events that may affect your business, and suddenly you find that you need to respond promptly with a plan in which your IP is a part and is heavily considered. So having an up-to-date IP inventory and strategy can save you so much time in these critical moments and is really just like a good contingency to have as a business. And then, of course, you want to keep in mind infringement as well. A good IP strategy includes actions to keep an eye on surrounding IP to monitor the market and the competitors. So, according to you, at what point should Bianca have reassessed her IP strategy? Well, at the time of exporting, she should have conducted a reassessment. Everything was going well in Canada. She had good sales and was considering doing business abroad. So what was her plan for after that? Who were the key players to consider in those targeted countries? Is there a similar product already existing in those locations? And is there protected intellectual property to keep in mind? It's really important to reassess your IP strategy at the right time in order to avoid these common mistakes that we've discussed previously, and then also as we've seen by examining this video further. In summary, your IP strategy is a part of your business strategy. It should help you answer questions like how, when, and where your IP is protecting your unique offer, how your IP is different to that of your competitors, actions you're taking not to lose your IP, and how much will all of these efforts cost. Your IP strategy is your plan to explain how you will use your IP to achieve your business objectives. So, of course, a recap of the steps that we discussed, start off with an internal and an external IP audit, analyze your findings and create your plan, implement your IP strategy, and lastly, remember to reassess and realign your IP strategy when necessary and keep all these external factors that might potentially affect the strategy in mind. So all of the resources, materials, and tools that I've talked about contain a wealth of useful IP-related content, and they're available in different formats such as audio, video, text, interactive on the CIPO website. We are happy to guide you and give you as much information as possible on IP rights, but unfortunately we cannot provide you with legal advice, and all of the questions that you see on this slide that are common questions are unfortunately questions that require a legal opinion. So you might also find that beyond these questions, you might find that you need help in understanding complex topics or obtaining legal advice in the case of infringement, or seeking an opinion on strategic positioning and searching advanced databases. So to that effect, there are of course groups and associations of IP professionals that you could turn to that will be able to address those questions. So to locate a licensed IP agent near you, you can contact the College of Patent and Trademark Agents, or CIPATA, which is the newly formed organization responsible for the management of IP agents. So we recommend that you only deal with IP agents that are on the CIPATA list of registered IP agents. These are individuals that have passed IP-related exams. They're regulated and disciplined by the CIPATA, so you know that they're reliable. Unfortunately, there are individuals out there who will pose as IP experts despite, not having the required credentials. So it's really important that you stay diligent and consult with the CIPATA website to ensure that you know exactly who you're dealing with and hiring to assist you with such a critical consideration of a business like your IP rights. And then, of course, we have the Intellectual Property Institute of Canada, or IPIC, and then the Bar Association as well. Those are two professional associations that you can look to in order to find a lawyer or any IP professional. Please do not hesitate to contact us if you have any further questions or need help finding any of the resources on our website. You can reach us via the contact information that you see on the screen. And then, of course, you can also, as I mentioned before, contact our intellectual property advisors for a more specific and tailored discussion to your needs by scanning the QR code that you see here. And then for any general questions about IP, feel free to reach out to our customer services center, either by phone or email. The toll-free number is provided on the screen. And then I invite you to follow us on all of our different social media profiles, as you can see on the screen as well. And then, of course, I also recommend exploring the CIPO newsletter titled IP for Business News, where you can find information about new IP products, seminars, webinars, upcoming events, updates and new additions to the CIPO website, and much more. So this concludes the webinar today on building an IP strategy. I hope you've learned more and thoroughly enjoyed this presentation. To further explore some of the other topics related to intellectual property that we've talked about today, I invite you to watch our other videos and to register for our live webinars on our website. And of course, I'd like to thank you for watching and wish you a wonderful rest of your day.